Good afternoon again, everyone. Thanks very much for joining us today for this event on cities and human rights that's co-organized by the UCL Institute for Human Rights and the Global Center for Democratic Constitutionalism, GCDC. So I'm very excited to be hosting this event here on cities and human rights. Urban collectives as victims of international human rights violations is the subheading with a wonderful speaker, Professor Marius Pieterse. A few words on our speakers and our commentator, Elena de Nictolis. Marius is a professor in the School of Law at the University of Witwatersand in Johannesburg, South Africa, where he teaches urban and local government law, constitutional law, and human rights law. He writes a lot on issues of local urban governance and on various aspects of economic and social rights. We have been very lucky to have him at UCL as a visitor this term, as a visiting professor this term, earlier in the term. Now he's not based at UCL anymore, but he's still with us for this event, which is wonderful. I've known Marius's work since I was a PhD student many years ago. I loved his articles that I read back then, so it's wonderful to meet him for me this term and to host him also particularly today. Elena is assistant professor of research at Lewis University in Rome and a visiting fellow at the NYU Law School's Guarini Center on Environmental Law. She holds a degree in politics and government and a PhD in political theory from Lewis University and is currently an LLM candidate. She's just awaiting her results. So we will have Marius speak for about 20 minutes, and then Elena will comment for about 10 minutes. I'll be very strict with time. Marius has slides, which we'll have on the screen. And after the presentation and comments, we will have about 20 minutes for discussion. Okay, Marius.
Thank you, Virginia, and also for having me and for hosting this event with the GCDC. Yes, my slides are intimidatingly in front of me. I'm presenting a paper on cities and human rights or I've been working on cities and human rights more broadly, and I'm presenting a subset of that work, which is urban collectives as victims of international human rights violations, based on something that I've just published and that tries to do too much, but that simultaneously is part of a broader project on how urban local governments use rights and public law, and how that overlaps with the challenges that urbanization poses for human rights law more broadly. And so I am interested in how rights and public law principles are evolving in the urban era, and how that overlaps with the current era of sort of environmental crisis. And so what I'm presenting today kind of touches on all of this. I can click there. There has in recent years been quite a lot of work in international law scholarship and in human rights law scholarship in particular, around the rise of cities. And when lawyers work with cities, they typically understand them as urban local government, and which is something that I also do, while at the same time I'm going to argue that we must look far broader than just that. In international human rights law, cities conventionally lack status and subjectivity. International human rights law, as you know, fixates mostly on states, though it does see individuals and increasingly it sees multinational corporations. But as government entities, international law sees cities as organs of state, who must obey international law as part of the state, and then if they don't, it's the state that gets held in breach. And when it comes to human rights, international law recognizes that local governments play an important role in implementing rights, especially social and economic rights, and as such also that they can often violate rights. But international human rights law would then hold the state responsible for that violation. In recent years, though, as many of you know, city governments have gained a lot of prominence both in international relations through, for example, the activities of city networks, and they've also gained a lot of power within constitutional law within different domestic systems of constitutional law through various delegation arrangements. And at both of these planes, a lot of this is revolved around asserting rights of the local government, but also of the people they represent. And so it's today recognized even by international lawyers that what cities do in the terrain of human rights is significant, that they contribute to the evolution of human rights norms as implementers, as violators, sometimes as protectors and formulators. But all of this concerns the ways in which cities are like states. And of course, they're more than that. Sometimes parts of them behave like organized non-state actors, corporations of civil society, not forgetting that both of these are also often involved in contemporary urban governance arrangements. Sometimes they behave like individuals, given that they house many millions of them. And over and above this, they're places. They're places where things happen, where human rights violations happen. And so in certain ways, they can be victims of these violations, or at least they can house all or most of the victims of a particular violation. And so I tried to look at how case law of international human rights tribunals deals with instances in which a fairly large human rights violation happens in or to a city. Who claims this? How is it depicted and adjudicated? Is it possible to capture and remedy the full extent of it? And what I found in the literature fell in more or less the three categories on the slide. Instances where urban governance failure causes or contributes to some calamitous event. The Beirut blast, which is on the slide, is a nice example of that. Secondly, where in armed conflict, urban life or urban fabric is deliberately destroyed. What a strand of the literature calls herbicide. There's unfortunately a great many examples of this. Aleppo, Mariupol, Gaza City. And then thirdly, where pollution or contamination or something similar harms all or most of the residents in a particular city. There's a UN Special Rapporteur on the environment report speaking of industrial towns or cities as sacrifice zones where residents' health or well-being are being sacrificed for economic gain. And then there are several instances where all three of these sort of overlap, which is something we see increasingly and will see increasingly as the climate crisis intensifies. So to capture and address such violations in a single human rights application is, of course, tricky because they're complicated and multi-layered, and they involve multiple rights and multiple people who will have been differently and unevenly impacted by the event or the source of the violation, and they're also differently positioned in relation to it. In fact, they may even be conflicted about it, like in the case of a sacrifice city where some work for or live in housing provided by the polluting company. And then even in less sort of layered violations, issues of representation are complex. Who represents the urban collective? Local government may well be well placed to represent residents. Other times they're not. Sometimes they will be part of the problem. Civil society representation comes with risks of capture and agendas and misrepresentation. And for individuals or small groups, it's both about access to justice and about whether the personal situation of the individual plaintiff adequately captures or represents the broader harm. It's also quite difficult to frame a challenge against the national state in terms of its obligations, as international law insists one does, when the kind of violations we're talking about here are often perpetrated by a mix of public and private actors at different levels. And then there are also the overarching limitations of legal rights in most international and regional treaty-based systems. Group rights, for example, are either absent or they're poorly developed or poorly understood, whereas the well-developed rights that do exist might have been given a narrow or an overly individualist meaning by tribunals over time. But it is the kind of violation that's occurring more and more, and the kind of claims that are increasingly sort of made and filtering up to international level. And so what needs to develop are our understandings of standing, of application of rights norms, and then of interpreting rights and of remedies in cases where violations have been found. We're certainly seeing domestic courts in different constitutional systems increasingly grappling with urban collectives when it comes to enforcing human rights, and systems that guarantee socioeconomic or environmental rights, even in cases brought by single plaintiffs. Claims are often based on collective harm, and cases often happen to be about cities or by or against local governments. In South Africa, where I'm from, for instance, socioeconomic rights have been justiciable since 1996, and after 3 of the first 4 cases dealt with shortcomings of national policies, almost all the cases over the next 20 years or so have been about local government housing and service delivery obligations in the country's 8 major cities. In systems where local government has standing to sue and where intergovernmental disputes are justiciable, city governments increasingly rely on rights of residents in disputes with upper levels of state. And we're also increasingly seeing local government represent citizens in suits against private entities. In the US, there's an increasing phenomenon of mass tort suits brought by cities against, for example, polluting companies, manufacturers of guns and lead paint and opioids and so on, claiming compensation for the often public health costs associated with harm from these events. And all these kinds of claims run into various difficulties, and as with individual claims, it sometimes happens that the domestic system doesn't give appropriate relief, and where plaintiffs resort then to the international system, where they then run into the state-centeredness of international law. And this is so especially at international level, where the ICJ, for instance, deals only with interstate complaints, and in the UN system, socioeconomic rights have only recently become justiciable, and all the complaints that the committee has heard thus far is focused on individual claimants. Environmental rights have only just been recognized and not in a treaty. And the Human Rights Committee has interpreted rights in the International Covenant on Civil and Political Rights, with the exception of the right to life to an extent, very individualistically. And there's not really been sort of global level cases concerning grand calamities of the kind that I'm interested in. Environmental cases have typically been cast in an individual mode or have been channeled elsewhere. And it often happens that the sort of urban collective element of a case gets lost as it filters out through the system. An example of how this has combined with the state-centeredness to completely obscure a violation is the ICJ's famous pulp mills on the River Uruguay case, which started, for comic relief, going to be butchering a lot of place names as I go through this talk. It started when residents of Guayaquil in Argentina protested the construction of pulp mills on the Uruguayan side of the river. Their famous international bridge blockade is on the slide. And it was because of the effect that it would have on the city. In Argentina, they also relied on constitutional environmental right in a lawsuit. They did file a complaint before the Inter-American Commission of Human Rights. But by the time it reached the ICJ in the way that it did, there's nothing on any of this. It turns into a very dry dispute between two states on the obligations of a river use and protection bilateral treaty. Where there's been some action has been around armed conflict and the Geneva Conventions. The ICJ found as far back as its nuclear weapons opinion that human rights law and humanitarian law both operate in armed conflict, which I argue kind of opens the door for more collective concerns to be vindicated, because humanitarian law is sort of more accommodative of collective concerns. It often concerns civilian populations as a whole, and there's rules about sieges and destruction of civilian infrastructure and so on that can inform a simultaneous vindication of say, the right to life. And so it's probably not a coincidence then that the case I could find that comes closest to engaging collective urban concerns has been one where the ICJ used humanitarian and human rights law together in its advisory opinion on the legal consequences of the wall in occupied Palestine, where it found that Israel was breaching various provisions of the Geneva Conventions and the International Covenants on Civil and Political and Social and Economic and Cultural Rights. Specifically, there were findings that I found interesting pertaining to the impact of the wall in East Jerusalem, where it divided the city, destroyed urban fabric and infrastructure, and altered everyday urban life. And then also the city of Calcalia, which was enclaved by the wall, and which complicated access to water sources, schools, and hospitals. The ICJ found violations of rights to health, work, education, and an adequate standard of living, as well as the right to freedom of movement of the people of East Jerusalem and Kalkilia. So speaking of them as a group based on their common urban residence. Yeah, that's what I could find internationally. To move to regional human rights systems, there's been plenty of action, but also plenty of hurdles before the European Court of Human Rights. First, the court has an extensive standing jurisprudence that quite uncompromisingly restricts access only to claims brought by individuals, groups of similarly situated named individuals, and NGOs. Two features of this jurisprudence restrict urban collective claims. First, the court has been quite unyielding that the European Convention does not allow an actio popularis, a public interest action, which would obviously limit the size of groups to listed plaintiffs. And then secondly, it regards local government and local government officials as organs of state and thus as agents of the respondents, so they're incapable of being plaintiffs. It has stated that municipal qualms, however rights-based these may be, must be solved domestically through intergovernmental relations disputes structures, which is fair enough, I suppose, but together these entry requirements do stunt the kind of claims that I'm interested in. And we've recently had a good illustration of this with the Graham case, one of the trio of climate change judgments that the court handed down in 2023 or early last year. It was brought by the former mayor of Consent, municipality adjacent to Dunkirk, claiming against France for failing to take adequate measures to prevent climate change, thereby threatening the town, which is in danger of being submerged by rising sea levels. And the case was dismissed for lack of standing because the plaintiff wasn't living in this town anymore at the time, owned no property there, and in his official capacity as former mayor, which led the litigation before domestic tribunals, wasn't allowed due to the fact that that would have made him an organ of state. So the claims that the court has allowed have typically been brought by smaller numbers of listed applicants, sometimes only one, even where the violation impacted an entire neighborhood or town. Interesting urban collective cases all invoked combinations of the same free rights, the right to life in Article 2, the right to peaceful enjoyment of possessions in Article 1 of Protocol 1, and the right to respect for home and family life in Article 8 of the Convention. Only the first two have been invoked in my sort of calamitous event cases. The famous Onurildis case versus Turkey, where the court first held that the right to life placed positive obligations on states to protect life and present loss of life was brought by a resident in an informal settlement where houses was destroyed and family members were killed after a methane explosion at a rubbish tip on the outskirts of Istanbul caused a landslide which buried much of the settlement, killing 39. It occurred after several years of unneeded warnings and efforts by local politicians, and so the court held that authorities violated the rights to life and property through their negligence and indifference, and it ordered Turkey to pay damages to the applicant, which is kind of not a small-scale example of what I'm interested in. But this reasoning was then sufficiently upscaled in Budayeva versus Russia to a situation where the entire town of Telmas on the slide was buried in a mudslide after Russian authorities failed to repair the mud barriers and to maintain early warning systems. And the applicants lived in a block of flats which collapsed in the slide and water damages, and Russia had to ensure that similarly situated residents could also be adequately compensated under domestic law. The court has decided quite a large number of cases concerning urban pollution, but there it has typically declined to consider right to life allegations and focused instead on the right to respect for home and family life, which it has consistently interpreted very individualistically to prevent the right turning into a public interest environmental right. So it's insisted that individual claimants prove that their home life has been significantly impaired by the pollution, and then it conducts a proportionality assessment where it weighs this individual impairment against the public interests, which then I'll say more about that later. But there's been several cases where the state was held liable, of which Fadayeva versus Russia is a nice example. The applicant lived in a block of flats near a steel plant in the city of Sheripovets on the slide. in a zone earmarked for evacuation because of toxic air, but authorities never did get around to relocating the residents. And the applicant developed serious health problems. Court found that Russia's measures to reduce the pollution were inadequate, that the burden on residents in the evacuation zone was disproportionate, and so found a violation of Article 8. Court also decided several armed conflict cases where it found violations of the same sort of cluster of rights. These have all pertained to small villages that were sieged and destroyed and had residents chased out in the course of internal armed conflicts, of which the Dogon case versus Turkey is probably best known. They've not been urban in their orientation, the cases, but in particular, when it comes to the right to property, I thought that the interpretation of the right, the notion of possessions, which in Dogon was interpreted to include the economic benefits that villagers derive from common lands in the village, sort of opens the door for claims pertaining to destruction of urban infrastructure and public space, although, of course, whether this manifests remains to be seen. 2 minutes. The other two regional human rights systems have had less cases, so 2 minutes. That fit my bill in the European system, but the ones that they did have been far more on point, and the judgments have been far better captured the nature and the reach of the violations, which I kind of ascribe to the fact that they guarantee a broader range of rights that are more appropriate to collective claims. In the inter-American system, the court can consider claims based on several socioeconomic rights, and it's got an environmental right. Previously, it's vindicated this right only for indigenous groups, but then came the La Arroya case in 2023. La Arroya famously being called one of the 10 most polluted places on Earth. Levels of lead in the air, water, and residents' blood samples are in far in excess of standards, both nationally and internationally. An NGO brought a case on behalf of 80 named residents. By the time it reaches the Inter-American Court, Peru wanted the relief confined to those 80, but the NGO submitted various briefs asking the court to consider the broader violation. Court took a midway approach, awards damages only to the 80, but makes several additional orders that pertain to the whole city as such. In relation to the right to life, the right to a healthy environment, the right to health. I'll say more about how it interpreted the rights during Q&A time. In addition to the damages that had to be paid to the listed applicants, the court also required Peru to develop a detailed plan to reduce the pollution and to decontaminate the city, which included restoring its ecosystem and providing appropriate healthcare to all residents in the city. I'm going to have to run over for the African system, and I apologize. The African system was obviously particularly interesting to me because it's the one closest to me, but also because the African Charter on Human and People's Rights contains a number of group rights and environmental rights that might be particularly useful to urban collectives. Although previously this was only mostly hinted at, the most famous judgment by the African Commission in the Serac case sort of dealt with pollution and devastation brought about by urbanization and industrialization rather than to a rural area rather than in an urban area. And the Commission also had a fairly extensive jurisprudence pertaining to armed conflict, but like the European Court, this was more at a village level. But then in September of 2024, the African Court on Human Rights, or was it 23, handed down judgment in the Lido versus Cote d'Ivoire case brought by an NGO in the public interest, because that kind of standing is allowed in the African system, pertaining to the dumping in 2006 of a large amount of toxic waste offloaded from a cargo ship in Abidjan's port, where thousands of residents presented for urgent care at hospitals during the same day. 17 people died, more than 100,000 people had serious health consequences. The court ultimately found violations of rights to life, health, to a satisfactory environment, and to receive adequate information, and ordered the state to pay compensation to the thousands of listed plaintiffs, but then also a list of remedies that pertain to all residents in the city, specifically pertaining to health care and rehabilitation. So to briefly then sort of step back and try and conclude, and I have timed this very poorly, to just sort of say urbanization has profoundly changed the ways that human rights are experienced and enacted and infringed around the world. And we need for the systems through which we vindicate them to start catching up. First, they need to reevaluate their approaches to standing, to reconsider their stance towards collective standing and representative standing, local governments perhaps. Secondly, the contrast between how collective claims are vindicated in the European versus inter-American and African systems speaks to the need to develop the content of group rights and the collective dimensions of individual rights. The European Court, for instance, is doing well with perceiving collectives' right to life violations, but its individualist focus on the right to respect for home and family skews its proportionality inquiry by depicting it as a balance between individual and collective interests, whereas actually it's collective interests on both sides of this balance that need to be reconciled. This also leads to an overly individualized approach to remedies, where individual compensation doesn't quite cut it, but for the kind of violations that I've discussed, but the more positive measures of the inter-American and African courts are more like it. And then finally, I think much as my paper doesn't do much with it, what I've discussed here sort of points to the need for greater conversations between international human rights law and domestic constitutional law systems, where cities have increasing autonomy and subjectivity, and where these kinds of violations both occur and get captured at the present moment far more accurate. I'm sorry for trying this clearly, but I'm done.
Thanks. Will you join me in thanking Marius for an excellent presentation? It's a very great paper, and it just took a few extra minutes, which is fine. And it is published. It was just published in the European Journal of International Law, so you can read the paper in detail and find all the information on the cases, I mean, but also the great argument that Marius develops. And Elena, we look forward to your comments.
Thank you. Thank you, Marius, for the presentation. And as Virginia just said, thank you for giving me the opportunity of spending a bit of time on this, because the paper was really very rich, both in a descriptive way, but also analytical. So thank you for writing it. I know it must have been quite a journey. So my comments are going to be, so since you've already introduced the paper, I'm going to go straight to the point. And I will focus on what I think are two massive contributions of the paper to certainly international human rights law and human rights law in general, but also, as you mentioned, domestic and constitutional law, regardless of the jurisdiction. I think your paper is going to offer insights too in the way that we think about cities and rights litigation. And then I will also mention two elements that emerge from your paper that you touch maybe a bit in a tangential way, but you might explore in further research, hopefully. So let's start with the first point. So this angle that you give, that you take and that you offer of urban collectives, both urban collectives as subjects, but also urban collective rights violation, I think it's going to be extremely useful for two points in the existing debates on citizen rights litigation. First of all, it helps us to get out of the corner of city-led litigation, so when cities are plaintiffs, and how this is perceived by courts as something they don't want to, they want to restrain from, because they are afraid of getting into intergovernmental issues and ultimately deciding on the nature of city governments as constitutional actor. Why I think your angle on urban collectives offer a way out? Because those of us that have looked into these cases in details, the way you did, know that when city governments are plaintiffs, they are genuinely advocating for the rights of urban collectives. They are genuinely advocating and helping their residents seek and hopefully achieve justice. We know that this was the case in Carême v. France, but it's the case in many of the US cases you also mentioned. However, and one of the reasons why they might do it, I mean, one of the reasons why we might think that it's good that we allow city governments to do this, it's because they have resources that are not always to be taken for litigation is costly. So vulnerable communities may not have the resources, time, expertise, money that are needed to pursue this type of litigation. So it makes sense that the cities use their own resources to do it. And yes, maybe there is some political gaming in there, but not necessarily. We know, we've read those cases, so we know that they're genuine. However, the fact that they are governments brings the attention out of the human rights violation and into the fact that courts want to, refrain from, allowing what ultimately is a government, to go against its own government. And so they don't want to deal with that thing. And it's easy to accuse US cities or cities like Grand Saint mayors to use this litigation strategically against maybe an opposite party in state laws. So this distracts, right? This issue distracts from the protection of the rights of these people. So is being a plaintiff the only way that city governments can support these communities? No, it's not. Because they could help the collectives that you talk about. If they genuinely want to, they can help them in other ways. You mentioned one case, for example, I believe it's the Côte d'Ivoire. Right now, I'm not looking at my notes, where actually the urban collectives say that they act on behalf of the city. So in some ways, your angle, I think, opens up the door for a collaboration, genuine one, between, sure, city governments that want to, that believe in, social and economic rights litigation. You mentioned city governments are not always good, but when they are, they can help in other ways if they really want to, which is not necessarily political in nature, and so can really keep the focus on this. So I think your paper is a major contribution to this, and it helps us. You mentioned, for example, Carême v. France. The court also restated that there is a robust case law that says cities are governmental actors according to the European Convention of Human Rights, and so they're just like, regardless of the specificity of this case, we know that he cannot represent the city as a mayor because we're not gonna take that. The other contribution, the other major contribution, which I think your article gives, is that this dimension of urban collective rights violation helps with issues of generational and cumulative damage. So, for example, again, coming back to the Carême v. case, but there are others, you mentioned several environmental justice cases. So usually these cases are read we read them as climate change cases, and rightfully so. And we know that one of the main issues in these cases is that because the damage is future and hypothetical, it's very difficult to assess. Now, in cases like Carême v. France, the court also used this to dismiss the case. So we know that they rejected it and they did it, but why? They embraced the interpretation given by the Council of State that because he could change their residence, okay, but what about the other people? Yeah, maybe Daniel Carême moved to Brussels, but what about, and also just because some people can move doesn't mean, but what about those who cannot, right? So obviously it's a complicated legal issue, right? But I think in some ways it's very important to solve them. And this urban collective dimension that you face, and the example given by all the cases, I think it's really key to help us, get out of this corner where, so in some ways cities, the cases that are about these cities and urban populations help us get out of this corner because they truly show the limitation probably of, this way of looking at this. Now, the 2 points that obviously it's not that they are underdeveloped in the paper, it's just that the paper wasn't something else, but you mentioned them. And so I think it would be amazing for us to think about it more. Number 1 is the legislative efforts. You quickly mentioned at some point, and correct me if I'm wrong, this is maybe where you want to go with this. It's not just litigation. There are efforts, and you mentioned the local governments association and how they write charters. That's absolutely true. there are legislative efforts that cities are pursuing, but also at the domestic and constitutional level that can really, I mean, we don't want to leave this only in the hands of courts, do we? So there is in particular one charter that you don't mention in the paper, but I think it's going to be very fascinating, which was at the center of a litigation here in the UK. The litigation was about something else. But I think it's very interesting. It's the Council of Europe's Charter of European Self-Government. So the case in the UK was about, so Scotland incorporated this treaty because they said we want to give cities this recognition and blah, blah, blah. The case ended up at the UK Supreme Court for another reason. So it has nothing to do with the charter itself. But I think that this is going to be an extremely important piece of the puzzle alongside the other charters you mentioned. And then the other point, which I think it's maybe emerged from your paper, but it's not clear to me what you think about it, is the comparative system angle. It seems to me that the African system and the inter-American system are doing way better than the European and the International Court of Justice one. And you don't say it in the paper, but I mean, the cases from the African court and from the Inter-American court are just amazing. Sorry, I'm done. So are just incredible. And so if that's right, now obviously it doesn't make any sense to tell to one court you should learn from another court, or maybe it does, comparative lawyers don't attack me, but you know, you could say that, you know, these cases just show that these courts, and of course supported by charters, so that calls for the legislative efforts, I'm just doing better. So you can say it, and we should learn from these examples, shouldn't we? So yeah, that's all, and thank you very much.